Yo, it's boom boom time again today. Let's get to the point since you guys have been clogging my DM begging for a topic on the EED defense. EED stands for Extreme Emotional Disturbance. This is actually a legal defense that can be used in criminal cases where a defendant's actions were driven by intense emotions or were caused by an overwhelming amount of stress. EED can be used as a defense to murder and attempted murder charges. Extreme Emotional Disturbance is a New York specific defense in murder cases only. To be clear, if you are found to have committed a murder under EED, you would be found not guilty of murder, but guilty of manslaughter. EED is a very different defense than claiming insanity or mental disease or defect. First, you must have suffered from such an extreme emotional disturbance that you suffered a profound loss of self-control. Whatever the emotion, whether it's sadness, anger, fear, or any other, it must be very intense. Second, there must be a reasonable explanation that you suffer this extreme emotion. The reasonableness is viewed from your own viewpoint and situation, not that of another person. Finally, you must commit the murder while under the influence of that extreme emotion. Oftentimes, this defense is compared with the example of walking in on your partner in bed with another person and acting immediately. In such a circumstance, even if a police officer were standing right next to you, you very well would have acted in the same way. Like mental disease or defect, while an expert witness is not mandatory, it's often necessary to support this defense. If you were in a minor car accident and you were so angry that you went and purposely killed the other driver, you may very well have suffered from extreme emotion, but most jurors would likely be to say that such emotion was reasonable because of an accident. If you planned some or all of the murder, it is less likely you acted under the influence of extreme emotion. Also, if there was a time frame when you could have cooled off, it is possible that the emotion lessened or ended, and you instead made a conscious, intentional choice to act as you did. You might be wondering how EED is used in court. The defendant must prove EED by preponderance of the evidence. The court considers how a reasonable person would have acted in the defendant's situation. EED can result in a reduced charge. EED and plea bargains. EED may make prosecutors more willing to offer plea bargains. Defendants who plead EED are more likely to succeed if they acted out of fear rather than anger. So, let's see how EED actually works. The defendant must prove that they experienced an extreme emotional reaction to an overwhelming situation. The defendant must have lost self-control due to the powerful emotions like anger, fear, or passion. The defendant must have a reasonable explanation for their actions. The court will consider the defendant's actions from the perspective of a reasonable person in the same situation. How it compares to other defenses. The EED defense is different from insanity or mental disease defenses. The EED defense is broader than the common law provocation defense. If you find that the people have not proven beyond a reasonable doubt any one of the elements, you must find the defendant not guilty of murder in the first or second degree. If you find that the people have proven beyond a reasonable doubt each of the elements, you must consider an affirmative defense the defense has raised. That defense, if proved, does not relieve the defendant of responsibility for the homicide, but under New York law, it reduces the degree of the crime from murder in the first or second degree to manslaughter in the first degree. Remember, if you have already found the defendant not guilty of murder in the first or second degree, you will not consider the affirmative defense. An affirmative defense is a legal strategy where a defendant accepts the basic facts of the case, but argues that they should not be held liable or should be held liable to a lesser extent due to the additional facts or circumstances. Essentially, it's a way to introduce new facts that, if proven, could negate or reduce the defendant's liability, even if the plaintiff's claims are true. Remember, it is not the act of killing that must be supported by reasonable explanation or excuse. It is the extreme emotional disturbance for which there must be a reasonable explanation or excuse. Under New York law, the defendant has the burden of proving this affirmative defense by a preponderance of the evidence. In determining whether the defendant has proven the affirmative defense by a preponderance of the evidence, you must consider any relevant evidence, whether introduced by the people or by the defendant. A preponderance of the evidence means the greater part of the believability and reliable evidence, not in terms of the number of witnesses or the length of time to present the evidence, but in terms of its quality and weight and convincing effect it has. For the affirmative defense to be proved by a preponderance of the evidence that supports the affirmative defense must be of such convincing quality as to outweigh any evidence to the contrary. If you find that a defendant has not proven the affirmative defense by a preponderance of the evidence, then based upon your initial determination that the people had proved beyond a reasonable doubt each and every element of murder in the first or second degree, you must find the defendant guilty of murder in either degree. If you find the defendant has proven the affirmative defense by a preponderance of the evidence, then you must find the defendant not guilty of murder in the first or second degree as charged in the indictment, but you must find the defendant guilty of the reduced charge of manslaughter in the first degree. Now let's talk about whether this EED can help Luigi or not. The problem is EED is not considered a defense in the federal system. And I am sure if they can make that, I'm not sure they can make that claim without putting Luigi on the stand. And putting Luigi on the stand is a bad decision, in my opinion. You guys have seen how much he loves to yap, 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 yap. Okay? To be honest, the essence of this EED is not a complete defense. It's an incomplete defense that just lowers it from murder one to manslaughter. In the New York State case, if the state goes first before the federal case, there's no way they could put Luigi on because his admissions that he did it, but that he was under extreme emotional distress, that could be used in the federal court, where there is no such defense.